Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about breathalyzers. Cases that should have gone to the Supreme Court of Canada, but didn't. Specifically, in the case where the Crown intends to rely on certificate evidence in a criminal case to prove what somebody's blood alcohol concentration was. This is the standard procedure in most impaired driving cases. The evidence of your blood alcohol concentration is printed out on a piece of paper, and that paper is filed in court as the evidence. And so long as that piece of paper is admissible, it's proof positive as to what your blood alcohol level was and that your blood alcohol level was over the limit. But that piece of paper comes with a lot of procedural and technical requirements, including that it be served on the defense with reasonable notice in advance of trial to allow the defense to respond to it and to understand the case against them. There are subsequent procedures in the criminal code that require, if the defense is going to apply to cross-examine the qualified technician who operated the breathalyzer or the analyst who checked the alcohol standard used with the instrument, those applications must be brought on 30 days notice to the Crown, 30 days in advance of the trial, which cumulatively makes 60 days. The argument, therefore, being that there should be at least 60 days notice in advance of the trial to file the certificate and give it to the defense to give them notice of the fact that this is going to be relied upon so the defense has the opportunity to bring those applications. Unfortunately, the Saskatchewan Court of Appeal disagreed, and leave was sought to the Supreme Court of Canada, who denied leave. And this case obviously raises a very important question. How can you interpret these time limits for strict compliance in the criminal code with the 30 days notice and 30 days in advance of trial application window while permitting the Crown to serve the document in the case at issue 7 days before the trial takes place? It can't possibly be appropriate for the court to simply say, well, the remedy is to seek an adjournment to bring the application, because justice delayed is justice denied. That's not consistent with the principles outlined in the Jordan decision of attempting to do things in the justice system to minimize delay, to get rid of the culture of complacency around delay. In fact, encouraging this process of less than 60 days notice for introduction of the certificate appears to be consistent with a culture of complacency, not the other way around. And to the extent that trials are adjourned, this is a complicating factor. It inconveniences witnesses, it inconveniences the court, it inconveniences the defendant, and it inconveniences the lawyers. And so you have all these parties that are put out simply because Crown can't be held to a standard of meeting a certain timeline that corresponds with timelines that the defense is required to strictly adhere to in the criminal code. Doesn't that seem a little bit unjust? Doesn't that seem like the scales are tipped more in favor of the prosecution than the defense? These are all the important questions the Supreme Court of Canada should have grappled with in this case and should have taken the opportunity to decide on. But unfortunately, they didn't agree to hear the issue, and they didn't agree, therefore, to determine whether it's appropriate to just give 7 days notice of a document that then requires the defense to take actions that can't possibly be completed in that period of time. It's unfortunate the Supreme Court of Canada didn't see the real injustices that are caused by this practice that is developing across the country and take the opportunity to intervene and correct it and course correct the way the justice system is going for impaired driving prosecutions. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.